SJC-11508, Commonwealth v. Sandro Tavares.
Mr. Shedd, good morning.
Good morning. My name is Dennis Shedd, and I'm representing Sandro Tavares. Tavares was convicted of premeditated murder and possession of a gun, and I'm planning on focusing on the lesser-included offense issues today, and I'll address others if the court has any questions about those. Tavares entered a bar, got into a brief argument with Giovanni Eason, and he left. He wasn't frisked when he entered the bar, so we don't know if he had a gun at that point or not. After he left, a fight breaks out between Eason, Emmanuel Pina, and others. When they get thrown out of the bar, the fight continues on the street.
What was the time gap between when Tavares left the bar and when he reappears outside with the gun?
He left the bar at about, on the video shows him going out at about 42 minutes, and he appears pointing the gun at Eason. I think it's about 46:38, about 4.5 minutes later.
Okay.
So the fight continues in the street. He and Tavares appears walking toward Eason, pointing the gun. Everybody backs off, and then Pina grabs the gun, chases Eason, fires shots, killing him and the cook in the bar, Manuel Montero. Now, the jury's instructed on premeditated murder and second-degree murder, and during deliberations, they ask if the joint venture has to be convicted of the same degree of murder as the principal. The parties agree that he does, and the judge instructs accordingly. But in a case where the evidence provides a basis for convicting the joint venture of a lesser offense, that answer was wrong. The Cunningham and Wood cases have established that a joint venture who participates in a crime should be convicted of the offense for which he has the necessary intent. That could be, it could be the same offense as the principal, it could be a lesser offense. But the jury instruction here prevented the jurors from considering whether Tavares should be convicted of a lesser offense. And that error created it.
So in a way, it's a, if I understand the argument, it's a, you would say it's a double error. I mean, in other words, if the instruction had been different, but no involuntary manslaughter, you might have gotten a second. Right. But, so they're independent but connected errors.
Right, exactly. So my argument is that this error created, in this case, a substantial likelihood of a miscarriage of justice. First, the jury question suggested at least that they were considering convicting Pina of first-degree murder and Tavares of second, and the evidence would have supported that verdict. The jury could have found that Pina, who was involved in the fight with the bar, who grabbed the gun, who chased Eason, firing at him, hitting him 3 times and Montero once, they could have found he was acting with the intent required for premeditated murder. But Tavares wasn't in the bar when the fight broke out. He didn't become aware of that until it spilled out into the street, and within seconds, he points the gun at Eason, Pina grabs the gun from him.
But Tavares had
they'd exchanged words in the bar.
Correct.
Yes, absolutely. So
with the victim.
Yeah, with the victim, that's right. But given that evidence, a jury could have concluded that the Commonwealth had proven malice but not premeditation. And a case that presented a somewhat similar issue is the Elliott case, which is described in the required findings section of the brief, but it's relevant here as well. In that case, the defendants beat up somebody. A couple of hours later, they were confronted by 2 of that person's friends. The defendant gets a rifle, points it at them, and when the co-defendant says, "Lace them," the defendant hands him the rifle, and he uses it. And the jury in that case convicted the co-defendant, the shooter, of first-degree murder, the defendant of second, and this court affirmed both those convictions. And as to the defendant, the court held that the evidence was sufficient to show third-prong malice. And Certainly the evidence of malice in that case is somewhat stronger than it is here, but it shows that facts like these can fall somewhere on that fine line between third-pronged malice and involuntary manslaughter, and that it can warrant convicting the joint venture and the principal of different offenses. So,
Now, would you go back to what the evidence precisely was? I gather with regard to the so-called either the grabbing of the gun, the handing of the gun, I gather it was not shown on video.
that's right.
So, but was there was there more than just characterizations in a single word of what occurred?
There were two witnesses who asked to describe how this transfer took place, and they both described it as, one witness described it as grabbing, the other witness at various times described it as grabbing, pulling, or taking. And they both agreed that Pina didn't appear to have difficulty getting it, but they did describe it as grabbing, pulling, or taking. It wasn't handing it to him or something like that. So in that respect, it differs from the Elliott case. So since the jury specifically asked whether the joint venture had to be convicted of the same degree of murder as the principal, one can't be confident that the verdict would have been the same had the judge given the correct answer. No, he doesn't have to be convicted of the same offense. Now, the evidence here also warranted an involuntary manslaughter instruction as to Tavares, and counsel's failure to request the instruction, the judge's failure to give it, also created a substantial likelihood of a miscarriage of justice.
Can I ask you about that? And just if you could address, you've got, I understand your client wasn't in the bar when the fight that went from the bar to the bathroom and then out into the street happened. Mm-hmm. But at the time that he appears on the scene outside, there's a fight that's about to start or has started in the street.
Right.
There's people all around, obviously, or it sounded like agitated and kind of involved. So to pull out, I guess, to appear on this scene with a gun out, drawn, is more than the likelihood of substantial harms. I guess that's what I'm getting. Is it really involuntary manslaughter, or does it move beyond recklessness at that point?
I think it doesn't move beyond recklessness. If I just describe what the evidence here is, the video shows Tavares approaching Eason, pointing the gun, and then everybody backs off. Eason and Tavares both back off. Eason goes to the right and then around to his car. Tavares goes to the left and out of view with a camera. And 7 seconds later, Pina appears running toward Eason with the gun in his hand. Again, the video doesn't show how that transfer took place. We've discussed how that happened. Now,
so your claim of recklessness would be that he was reckless in not securing the gun.
He was
introducing the gun and not securing it.
The argument here is that a jury could find that it was reckless to display a gun at the scene of a fight amidst a group of angry people, and that introducing a gun into that situation created a high probability of substantial harm, because people now know there's a gun present. It creates a risk that somebody's going to grab that gun and use it. And in other cases, this court has held
the introduction of the gun, or the introduction of the gun and the failure to secure it against a hot-headed friend who grabs it from him.
Well, I think it's just a matter of displaying the gun at that fight. Is he not? Can fall as recklessness. And again, this court has held that knowingly shooting at someone can only be third-pronged malice, but that's not what Tavares did. And if you know, the probability of death required for third-pronged malice is plain and strong likelihood, and for involuntary manslaughter, it's a high probability. If the jury thinks it's a high probability but not a plain and strong likelihood, we've got involuntary manslaughter. If they don't think there's a high probability, there's no crime. And displaying a gun at the scene of a fight could certainly be found to be a reckless act, and that it created a high probability of harm. It created the risk that somebody would grab the gun and use it.
So what do we make of the fact that I gather when Pina was running, chasing the victim, Tavares was right behind him?
Well, other people are right behind him too. I mean, some people, they see a gun about to be used, they run the other way. Some people want to see what's happening. I mean, the other witness who was in the street, who has helped him get people out of the bar, he was Pina goes running towards, and first that witness from the bar is the next person in line, and Tavares is after him. There's other people running after him, following these people. I don't think it shows that Tavares, that a jury could not find this as recklessness and not a plain and strong likelihood. And again, to distinguish this case from the Elliott case, and again, so unlike Elliott, the evidence here doesn't show that Tavares voluntarily handed the gun to Pina. The evidence is that Pina grabbed the gun. There's no evidence that they spoke to each other, so Tavares knew what Pina intended to do in this situation. So a jury could certainly find that there was given the choice, a jury could find that the evidence here created a high probability of harm, but not necessarily a plain and strong likelihood of harm. This isn't the case where Tavares was knowingly shooting at somebody. This is a case where somebody grabbed the gun from him, and again, once he pointed the gun, everybody backs off. So a jury could infer that when Tavares was pointing the gun, his intent was not necessarily to kill anybody. His intent was simply to break up that fight, and that's why he backed off at the same time Pina backed off. So a jury could conclude that but for Pina coming up.
Could the jury take into account, at least I think there was some testimony, that when he had the gun, he was trying to rack it and was having problems?
The witness who was in the bar claimed that he saw Tavares try to pull the slide back the chamber around. That's right. But the jury wasn't required to accept that, particularly since that witness, when he spoke to the police that night, stated that it was the shooter who was playing around with his side of the gun, not the first person who had it. And the witness who was in the middle of the street closest to the action didn't report seeing anything like that.
Sorry, could you just repeat what you just said about it was the shooter who did what?
The witness who at trial testified that Tavares tried to pull the slide back. When he spoke to the police that night, he said it was the shooter who was playing around with the side of the gun. He said the shooter did Pina. That, not the person later identified as Tavares. So that person said is the shooter who was trying to do that, not Tavares, but he changed the story at trial. And again, the other witness who was right there in the middle of the street close to the action didn't report seeing anything like that. So given the choice in this case, a jury could have found...
Was that the second witness that you mentioned, was the question put to him at trial, whether he did see anything like that?
No, they just asked him to describe what happened, and he didn't mention anything like that at any time. So it didn't go beyond that. Didn't go beyond that. So
the jury could have concluded. The jury could have, I was prompting you.
Right. If the jury had been given a choice, and they should have been given the choice of deciding where on the spectrum of harm this case fell. And as I said at the start, they could have found malice, not premeditation, but they didn't have to find plain and strong likelihood in this case either. They should have been given that option of deciding where on the spectrum of risk this case fell, and they weren't given that choice. So had the judge correctly answered the jury question, and had they been instructed on involuntary manslaughter, there's very good reason to believe in this case that the verdict would have been different, and Sandro Tavares should be granted a new trial. And unless there are any questions on the other issues.
Now, we're in a substantial likelihood world because I guess defense counsel did not ask for an involuntary manslaughter instruction and said that the judge was correct in telling the jury that it must be the same shared intent.
Well, I think that's part of the problem. Is he wrongly agreed with the DA and the judge that the two parties had to be convicted of the same offense, and that could very well be the reason he didn't request and the judge didn't give an involuntary manslaughter instruction. They thought they had to be convicted of the same offense. There was no basis for an involuntary manslaughter instruction as to Pina. Therefore, there couldn't be a basis for an instruction as to Tavares either. But the foundation of that was just plain wrong.
But what about as instructed, if the jury, I mean, they still came back with a finding that he must have shared the same intent as Pina. I mean, the option that they were given was either they had to have either guilty of first-degree murder or not guilty.
Right.
That was the option that was on the table. They came
Well,
back
on the
with,
table, they had first-degree murder, second-degree murder, or a not guilty, but then the judge instructs that he has to be guilty of the same thing as Pena, so that sort of puts second-degree murder out the window.
Okay.
And then I think you come down to the Woodward situation, where the jury is given this choice of he's guilty of something, but our choice is first degree or not guilty. On the whole, we'll take the first degree because he's guilty of something.
All right, thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. Sarah Montgomery on behalf of the Commonwealth. We're asking this Court to affirm the defendant's convictions for the first-degree murder of Giovanni Eason and Manuel Montero in the early morning hours of August 2nd, 2009, and also his conviction for unlawful possession of a firearm. Your Honors, a clear understanding of the facts of this case, as was alluded to in my brother's argument, is crucial for resolving the legal issues here, and I just would like to point out at the outset, suggest to the Court, if you've not already done so, to view the video evidence in this case. Specifically, I would direct your attention to Exhibit 25B, and the Commonwealth has filed an assent to motion to transmit that exhibit to this Court. It's a frame-by-frame view of the various camera angles put into sequential order. And I would also suggest that you simultaneously read Sergeant Detective Wise's testimony.
I'm sorry,
Sergeant Detective Wise's testimony narrating the frame-by-frame view in Exhibit 25B, and that can be found at transcript volume 9, pages 188 to 203. With that in mind, I would like to first comment briefly on the sufficiency of the evidence in this case supporting the first-degree murder convictions. The events in this case occurred over a 7-minute period, 7 to 8 minute period. And during that time, the defendant and Pena engaged in a continuous course of conduct together that showed their shared intent to murder Giovanni Eason and through theory of transferred intent, Manuel Montero. The defendant, as you'll see in the video, wearing a black shirt with white writing on the front, walks down Hancock Street towards Carlos with 2 others, one of whom the jury could have reasonably inferred was Pena.
Well, Mr. Shedd disputes that suggests that that third person, despite the fact that the prosecutor identified him as Pena in his closing argument, but that really wasn't. It wasn't in evidence, and he was never identified.
The video, that is an argument that my brother makes. The video is in evidence, and it was played for the jury continuously, along with the eyewitness and identification witnesses' testimony, and it was for the jury to determine that issue. Even if it wasn't, if the jury couldn't have reasonably concluded, which the Commonwealth wouldn't concede that it was Pena, Pena was identified in the first instance walking into view from the direction that the defendant and he had walked from down Hancock Street towards Carlos. He is then, well, let me back up for a moment. The defendant walks into the bar and he initiates this confrontation with the victim, Giovanni Eason, and he then walks out. Pena is then seen on the phone outside the bar. He then walks in and straight to the bathroom where he engages in a fight with, again, Giovanni Eason, the very person that the defendant had instigated this exchange of words with. Meanwhile, the defendant returns to Carlos with a loaded firearm and is lurking outside the bar until the others exit the bar.
Do the videos actually show him outside before other people come out of the bar?
It does. It shows him on the side of the building, and you can see that. Again, Exhibit 25B is clear on that point, and the other video in this case. So the defendant is clearly, is on the side of the building. The person in the black shirt with the white writing, waiting for, arguably, as the jury could have inferred, in light most favorable to the Commonwealth, waiting for Eason, the target, the person who was targeted by both Pena and the defendant, to exit the bar. Eventually, you will see the defendant in the middle of Hancock Street, approaching Eason and pointing the firearm directly at him. And the testimony, I would like to comment on the first the racking of the gun and also the exchange of the gun, as it was discussed in my brother's argument. The witness who was viewing this from inside the bar, Joie de Pina, did testify to the fact that the defendant racked the gun. He also did not use the word rack, but he used the word pull in the grand jury, and that was before the jury as well. That there was consistent testimony on that point. In terms of the exchange of the gun,
but did he in fact also tell the police it was the shooter who had done that?
On the night of the murder, during cross-examination, there was the defense counsel did question him about what he told the police, and he said that on that night that the Pina was playing with it, I believe. But there was no, even if we look with respect to the involuntary manslaughter instruction in the light most favorable to the defendant, there was no evidence that the defendant put on there was no evidence to the contrary that he wasn't racking the gun. He testified to that at trial and at the grand jury.
But are you telling us that this witness testified at trial that Pina had played with the gun and that Tavares had pulled the slide back on the gun? That they both handled the gun and did different things with it?
No. On direct examination, Joie de Pina testified that he observed the defendant rack the gun, and he was a former police officer, and he described that as pulling the slide back and making it ready to fire. He did not testify as to any actions by Pina of playing with the gun. His testimony was that Pina took the gun, and then when he was asked about how that occurred, he said that there was no resistance by the defendant whatsoever in that exchange. On cross-examination, the defense counsel for Tavares did explore what this witness, Joie de Pina, told the police on the night of the murder. On the night of the murder, he had said something along the lines of, and I would need to review it particularly, but something along the lines of Pina was playing with the gun. He did not say anything about whether the defendant had racked the gun. However, on redirect, the prosecutor did introduce the grand jury testimony, and in that testimony, the witness, Joie de Pina, testified consistently with his direct that the defendant had pulled the gun. So that's just an overview of that testimony.
Was there another witness who was also a recipient witness who testified about it and did not say that the gun had been racked?
There was another recipient witness, Alberto Brandao, if I'm saying that correctly. He did not testify in the negative saying he didn't rack it. It was just silent on that point. There was no testimony to that issue.
He said he observed the defendant.
He said he observed the defendant pointing this firearm at Eason, and that Pina then took the gun. And now this goes into the exchange portion, which I wanted to clarify, of the exchange of the firearm. The prosecutor asked, could you describe how that happened? He said he just grabbed it. And the prosecutor then explored that further and said, was there any resistance by the defendant? And Alberto, the identification witness, or the eyewitness, in this case said no, there was no resistance by the defendant. And I think the fair inference from the evidence is that it was a voluntary provision and exchange of this firearm. And also I think we are focusing on that point, but I think we have to look at, as I started, with its litany of facts and the entire circumstances and facts in this case, starting from when the defendant walked into that bar and ending with the fact that he is running down Hancock Street, following Eason. And Pina, who's shooting at Eason.
I mean, you began this by saying you wanted to address the sufficiency of the evidence, and I get that. But regardless of whether the evidence was sufficient for a first-degree murder conviction, the question that at least Mr. Shea, I appreciate he makes the sufficiency argument in his brief, but the question we're discussing here, I think, is, or focusing on, is whether nonetheless there was enough evidence for well, two things: enough evidence for a manslaughter, and then second, the problem with the jury instruction. But just, I mean, that's the view of the facts in favor of the Commonwealth, and it's, you know, it's strong. But one could also, I mean, or are you just disagreeing that there, as a matter of law, that there wasn't enough for a jury reasonably to conclude that he was reckless in bringing the gun outside, but he didn't have the intent, and it wasn't plain and strong likelihood of death or et cetera?
First, I am disagreeing that as a matter of law, the facts of this case did not support an involuntary manslaughter instruction, even in the light most favorable to the defendant. However, even if you could draw an inference from these facts that the defendant did not intend to kill here, and that he, in his view, he merely introduced this gun and pointed it at a crowd to scare them, then he would be entitled to an acquittal. The act of just pointing this gun at the crowd to take the racking out of it, and having no intent to kill here.
No, I don't know.
I think it becomes an issue of causation. I want to step back for one moment and just point out the defendant's theory of the case here, as it's important to this discussion, and I think it frames the discussion. We have to focus on the facts of this case and the circumstances of this case, and not extrapolate to others. Here, the defendant's strategy was to present an all-or-nothing choice to the jury. He did not want a compromised verdict. His argument, and it was clear in his closing argument, that the defendant didn't share Pina's intent to kill. Therefore, he was not an aider and abetter, and therefore he was not guilty. And if the jury rejected this, then he was guilty of murder. That was the defendant's theory in this case. He strategically made a strategic choice that cannot be second-guessed at this point.
That was the same theory of the defense in Woodward. But do we basically allow a judge, I mean, at Woodward, we said it was wrong for the judge not to have given a second-degree alternative, even though the defense said we don't want a second-degree alternative.
The second-degree alternative or involuntary manslaughter?
Oh, well, in Woodward, it was a second-degree,
right,
and probably an involuntary as well. But I mean, I guess it was only second-degree in Woodward, right?
Second-degree, I believe, was given in Woodward.
Right.
I believe that involuntary was not. The Commonwealth had requested it in Woodward, and the defendant
did not want
objected. There's a footnote in Woodward, and there's some other cases to support this. I believe it's Rogers, and I don't have the site, that the instructions should be given upon request. There was no request here, and the judge should not and properly did not interfere in the defendant's theory in the way he wanted to present his case. In Woodward, there was a request. It was by the Commonwealth, and it presented a different circumstance than is presented here, but there was absolutely no request by the defendant for this instruction. In fact, he requested an assault with a dangerous weapon instruction, which was denied. The judge said that wasn't charged in this case, and I think that request even further supports his theory that what his theory was is pointing this gun. All the defendant did was point this gun at this crowd. And that the act of Pina taking the gun from him was just some intervening event that made him have no causation, that the defendant in no way caused the death of these two people. And I do think it's an issue of causation, and the way that...
I guess it raises the interesting issue of whether he can throw the dice on behalf of a client in that regard. I mean, the jury was... Well, do you agree that a jury potentially could have found from this evidence that he had pulled the gun, perhaps not with an intent to kill, and did not resist when his buddy Pina, who he should have known had just been in a fight and was hot-blooded and potentially could have killed, that it was reckless. A jury could have found, not had to, but could have found that he was reckless for introducing a gun and not securing it against his friend.
I wouldn't agree that that was reckless if you look at the entire circumstances in the 7 to 8 minutes that this event occurred. But solely focusing on just introducing a gun and pointing it could have been reckless. He could have not had the intent to kill. Not in this case, but that could be a case. But that's not the way the defendant argued this case. He never argued that that was wanton and reckless conduct and that the defendant did not share Pina's intent to kill. He argued this in an all-or-nothing way, and I think that must be looked at by this court, and the defendant cannot engage in Monday morning quarterbacking by coming back and saying that he was entitled to an involuntary manslaughter instruction where it was never requested.
So this case is one step beyond Woodward, in which nobody asked for it.
I believe Woodward the Commonwealth did, but maybe
The Commonwealth here asked for an
voluntary
involuntary?
manslaughter, but I'm not.
In Woodward.
In Woodward?
Woodward they did, I understand.
Yes, oh.
But that's why this is one step beyond.
Yes,
Because
okay,
in
I
Woodward
thought you
there
were
was
asking.
somebody who asked for it.
You're-
And here, I gather, nobody asked for it.
You're correct. I misunderstood. Yes, I would agree with that, and I think this then goes into the jury question issue. Taking the defendant's strategy, which I've explained, the defense counsel is the one who proposed the answer that was effectively given to the jury. The defense counsel said, I think he agreed with the judge that the real question is that the real question that the jury was asking is the aider and abettor liable to the same degree as the perpetrator?
But if you posit that that's, I appreciate he said it, but if you posit that it's error, where are you?
I don't agree it's error. I would say in the first instance that he did posit it, and my point is that it was consistent with his theory at trial.
It may be consistent with his theory, but if it's legal error.
And I would next disagree that it's not legal error, particularly in the circumstances of this case. I think it's important to look at the question. The jury specifically identified person A in their question as the aider and abettor. I think implicit in the question is a finding that person A knowingly participated in the commission of this murder with the intent required to commit the crime. If you read the question in conjunction with the judge's prior charge on aiding and abetting.
Well, you could knowingly participate if you have one person who intends merely to shoot him in the leg, and the other person intends to kill.
That's correct, but not in this case. In this case, where the question specifically, first of all, the facts of this case, but then going to the question, person A shares person B's intent. Are they liable to the same degree? Yes, and I would disagree with.
They share it. The answer is yes, but the instruction is had or shared. The instruction given by the judge, which comes out of the Zanetti case, is that the defendant had or shared the intent. So it understands that you could have an intent but not necessarily share the intent.
Well, I agree with that, but I also think that I think we have to look at the facts of this case and the question. Here, the defendant did have the intent, and he did share the intent. Going to the question, the answer that was given was the aider and abettor is liable to the same degree as the perpetrator of the crime. Implicit in that question is that person A and person B do share the same intent.
That's what I was going to ask you. Are you saying that by phrasing the question, by using the term aider and abettor in the question, you infer that they meant they had concluded that the Zanetti definition was met, that he
Yes.
shared the intent to commit first-degree murder? I mean,
Yes.
that's the way you read it.
That is my way is the way I read the question, and I think it's a proper reading of the question. And I also would suggest that it does not preclude a second-degree murder finding for both of them. If they share...
Well, it's a little hard to find a second-degree murder for Pena.
I agree with that, and I think it's very hard to find second-degree murder for the defendant, where he walked into this bar, instigated an argument, left, returned with a gun, and lurked outside waiting for the victim to exit.
And your basis for saying he did not have the gun inside is because he was frisked when he went into the bar?
No,
I don't believe he was frisked. I think that he knew he had been to this bar. I believe there's testimony before, and knew that there was a bouncer.
Sorry, but how do you know that he didn't have the gun when he went in the bar in the first place?
The video doesn't show. That he didn't have it when he went in the first place. I think there's a fair inference that he didn't, because he knew that he could have been frisked. He went into the bar, searched by the bouncer. Went into the bar, empty-handed, left, and having instigated this fight, returned with that gun. I think it's a fair inference from the evidence.
But the bouncer did not testify that I frisked him and found no gun on him when he went inside.
I would have to review the testimony to that point. I believe it was explored. But I cannot specifically answer Your Honor's question on that point. I see that my time is up. I would just ask that the court affirm the defendant's convictions and decline to exercise its discretion to reduce the verdict or order a new trial.
Thank you.
Thank you, Your Honors.
And we'll take our morning break.